So Karen Reed and her attorneys and the Commonwealth through their attorney, no, not Lally, no, not Brennan, their appellate attorney, argued to the Supreme Judicial Court. The defense had made motions that were legally difficult at best to dismiss the counts of Karen Reed's case they say that the jury came to verdicts on. I understand where they are coming from when numerous jurors reached out and said, hey, we had verdicts on two of the most serious counts, counts 1 and counts 3. We had verdicts, but then we came into court and we couldn't resolve the second count, and then it just got dismissed and we just got put back on a bus and we had no idea WTF is even happening, but we had verdicts on 2 of the counts. And the argument is legally, are those final verdicts if they are not written down? Like, is that your final answer? Like, when you say deal or no deal, is it final till you like hit the button? So if it's not written down, is it a final verdict? And I find this entire circumstance deeply frustrating because it remains my position that had the jury just been polled, this would have been resolved in the courtroom before the jury was dismissed. I believe the jurors that said this all happened really fast. However, I have been told by many that it is not the common practice to poll juries in Massachusetts. And it is true that neither side asked for the jury to be polled and had the opportunity to do so. So there are some legal nuances here that are difficult because where we stand now, I don't love at all that the jury wasn't polled. Can't go back and do that. Can't unring that bell. And I also don't love that they didn't hear from the jurors, which we have seen in case after case in different jurisdictions, where they brought the jury back in and was like, tell me more. And I wanted to hear from the rest of these jurors because 3 jurors saying something doesn't make it true. I wanted to hear from all 12 jurors. I thought that was an unrealistic ask, but I wanted it anyway. Sometimes we don't get what we want. At the end of the day, this was a difficult motion for the defense. It was always going to be a difficult motion for the defense. They were asking the court to do something that is very outside of the normal because this is an incredibly unusual circumstance. It is rare that you have jurors saying, no, wait, we reached a verdict after a hung verdict is declared and the jurors are dismissed from the courtroom. The jury was not polled. The jurors did not speak up. The defense didn't ask for the juries to be polled. And the court relied heavily on the notes of the jurors. The notes were unambiguous. The notes did not say, we are decided on some counts, undecided on others. And ultimately, that is what the Supreme Judicial Court leaned into in their decision to deny Karen Reed's motion to either reconsider allowing them to have an inquiry with the jury or to find that the judge improperly declared a mistrial. Even if they'd been allowed to inquire into the jurors, there is still not a remedy under the law that would allow a jury that's been dismissed to render a verdict. For me, I saw the ability to ask each of the 12 jurors if they had actually rendered a verdict on counts 1 and 3 as the appropriate information needed for the defense to continue to argue that those counts should be dismissed and not retried. But that would still lie in the hands of the Commonwealth. And it seems the Commonwealth is disinclined to do that. So even if the jury inquiry had happened, there is no legal mechanism to go back and render a verdict after a mistrial is declared. And the Supreme Judicial Court kept in line with that prior case law. It's frustrating. It's a circumstance where it seems that the jurors felt that the judge would give them more information and they didn't get that more information and were frustrated after the fact. If you are ever on a jury and you are not sure what the judge is going to do, ask. Ask the bailiff that's dealing with the jury. Ask the court if you feel that you must. Ask the questions. It's better to get the answers than to leave it lingering. None of those notes from the jury, and we went back through them today, indicate that they had reached a verdict on some counts. If the notes had been less clear, or if the notes had indicated that they had reached some verdicts, this might have been a different result. But what happens from here? Trial starts on April 1st. There is no lingering ruling from the Supreme Judicial Court, and trial will begin again on April 1st. But if you're the Commonwealth, from my perspective, you have multiple jurors coming forward saying that there was not enough evidence on multiple counts in this case. It should give the Commonwealth pause going forward with those counts. It doesn't seem like it's going to, but it should. And if you're the defense, you know where your challenges are on those lesser includeds in count 2, the DUI related homicide counts. And that should also give the defense quite a lot of information in where they really dial in their closing arguments and their evidence in pointing out what the Commonwealth did not prove in the next trial. So the information from the jury is going to inform what happens in trial round 2. But trial round 2 is going to go forward as scheduled. You might remember that Trooper Proctor is in the middle of disciplinary hearings. Yesterday was day 2. Guess what? There's going to be a day 3. I know. This is coming to us from Boston 25. So this is from yesterday. Trooper Michael Proctor, lead investigator in Karen Reed case, faces state police trial board. This is a disciplinary action. He was at day 2 of a full hearing. Day 2 of the hearings wrapped on Monday at state police headquarters in Framingham without a conclusion. The next hearing is scheduled for March 13th. These are private. They are behind closed doors. So they are going into day 3. These are all of the due process. If he is going to be terminated, he has been suspended without pay since not very long after the mistrial. He continues suspended without pay, but these are the disciplinary hearings to see if he will be terminated or not. I hope that these will resolve before April, but we will see. If this gets kicked out past the next trial, I'm going to have some thoughts about it. But the hearings continue on March 13th. So it's getting close to trial time. That's the update on Trooper Proctor. The defense is asking the court for a simple request, really. On October 25th, 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. The defense is simply asking the court to order the Commonwealth to obtain and log this evidence in a forensically sound manner so that no additional exculpatory information is destroyed. This all centers around the stunning reveal that some computer has some video saved by some retired officer and maybe cloud storage. The defense indicates that they asked the special prosecutor on the case, Brennan, to forensically image the entire computer. Brennan, disinclined to acquiesce to that request, said, "You're going to need to make a motion to the court. I can understand the Commonwealth's hesitation to forensically image an entire department computer, but when the videos got on the computer, if any videos were deleted from the computer, when the computer accessed those, what file they saved them on, all the metadata related to those files is essential and should be turned over. But the original metadata, I think the defense is aware, is probably gone, but they are asking again. And it seems the defense found where that order was made in October of 2023. All videos and metadata need to be turned over, and the Commonwealth still has not complied with that order because all the metadata was not turned over. And even before the first trial, all the videos weren't turned over because videos were still coming in October of 2024, well after the first trial. This is groundwork for the motion to dismiss that the defense has a deadline of February 21st to turn it over. Will the court probably issue another order to turn it all over? Yeah, a duplicate of the other order. Is the Commonwealth going to be able to adhere to that order? It seems like maybe not. And if they can't, does that give the defense stronger and more grounds to make their motion to dismiss? I think so. And we will continue to see the defense hopefully methodically laying out these are the dates the court ordered things. The court said the metadata needed to be saved. The court said the videos needed to be turned over. And then these are the dates the videos were turned over, some not until the middle of the first trial with no metadata, and some not until after the first trial with no metadata. So not only is there an obligation for the Commonwealth to turn it over, but there is also additional court order making it very clear that it gets turned over with the metadata. How the court addresses the fact that that likely doesn't exist, we will see, because oral arguments are set for this in the beginning of March. But we are getting very close to that April 1st trial date with some very decisive motions still outstanding. So I think when we see the defense motion to dismiss, they are going to ask for it to be dismissed on all of these different grounds, including the destruction, they're going to argue, of exculpatory data. It's very hard for the defense to argue, Your Honor, they destroyed this, so we can't even tell you what it is because it doesn't exist. But I imagine the case law in Massachusetts will give guidance on what happens when things that can be exculpatory are destroyed, because you can't just say, well, it's gone, so now we can't argue that it's exculpatory. So we will see. That's not before the court just yet. I know everyone is ready for the court to just dismiss this case. I understand. The question's not before the court just yet. I'm interested to see what these motions to dismiss say. I'm interested to see what the Commonwealth says in response to this motion for the turning over of a forensically sound copy of all of these videos, because I wonder if that's even possible at this point. We'll have to see. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.